Good evening, everyone. Welcome to the Constitutional Law Podcast with Jefferson. Today I'd like to talk about Section 2 of the Canadian Charter. Section 2 deals with our fundamental freedoms. And today I'm going to be focusing on 2B. But first, I will read you all of the fundamental freedoms enshrined in Canada's Constitution. Everyone has the following fundamental freedoms. A. Freedom of conscience and religion. B. Freedom of thought, belief, opinion, and expression, including freedom of the press and other media of communication. C. Freedom of peaceful assembly. And D. Freedom of association. I'd like to walk you through a quick history of some scenarios that have arisen in Canadian society, specifically around defamation. Defamation is aimed at the prohibition of the publication of injurious false statements. It is grounded in the importance of one's reputation. In fact, under the common law, defamatory statements are assumed to be false and malicious. That is all the proof of harm required. Once you make a defamatory statement, the burden is on the one who made said statement to prove its truthfulness or to show that it falls within a range of statements we in Canada have decided are privileged and do not constitute defamation. To quote Carissima, Mathen, and Patrick Macklem from their Canadian Constitutional Law 6th edition textbook, the common law jealously guards individual reputation. I'll be briefly touching on some Supreme Court of Canada decisions in order to give you an overview of the state of defamation and how it restricts our freedom of expression as Canadians. First case I'll discuss is Hill and Church of Scientology, 1995, Supreme Court of Canada. In this situation, the Church of Scientology, through its counsel, made libelous remarks about Crown Prosecutor Corey Hill, claiming he had been instrumental in breaching an order of the court and that he was guilty of criminal contempt. The Supreme Court found this to be defamation, as the statements were untrue. One very interesting line of argumentation was that Corey Hill, at the time of this defamation, was a Crown attorney. He was promoted during the trials period, and it in reality appeared not to affect his reputation. This was responded to by saying that, quote, as a lawyer, Hill would have no way of knowing what members of the public, colleagues, other lawyers, and judges may have been affected by the dramatic presentation of the allegation that he had been instrumental in breaching this order of the court and that he was guilty of criminal contempt. He went on to say this nagging doubt and sense of hurt must have affected him in every telephone call he made and received in the course of his daily work, every letter that he sent and received, and in every appearance that he made before the courts of the province of Ontario. You can see this core protection of reputation and the considerations of what that does for someone going through it in their own mind. In two cases heard together, the situation where the media organization was publishing information that would be defamatory if it was a private individual, but of course there is an interest in protecting access to information for the general public. The first case, Grant and Torstar. Grant brought an action for defamation against a media company for a story published about his potential development of a golf course on the lakefront estate he owned. The story included local interviews theorizing he was able to use his political connections to Progressive Conservative Party member Mike Harris to sidestep environmental requirements. There was a key quote from this article that much of the litigation centered around. Quote, "Everyone thinks it's a done deal because of Grant's influence, but most of all his Mike Harris ties," says Lori Clark, who owns a cottage on Twin Lakes. Chief Justice Macklem wrote for the majority and ordered a new trial and that a defense of responsible communication on matters of public interest should be considered. This defense involves considering exactly two elements right in its name. First, the public interest, which is a question of law that would be decided by a judge, and second, the responsibility, which would be decided by the jury. Public interest does not mean what interests the public in general. It must be of important to some sector of the population. It shouldn't matter if most of the public is uninterested. A minority group still has full entitlement to material relevant to them. What really matters is that the public must have a genuine stake in knowing about the matter published, and that, of course, can just be a segment of the public. Responsibility question involves considering the seriousness of the allegation, the public importance of the matter, the status and reliability of the source, and whether the plaintiff's side of the story was sought and accurately reported. That last element of responsibility was the core question in Kwan and Kusin, which was seen concurrently. In that case, OPP Constable Kusin, with his pet dog Ranger, rushed to Manhattan's Ground Zero during 9/11. This was despite his offer of assistance having been declined by New York authorities. He was lauded as a hero in the press, but a later article in Ottawa Citizen reported allegations that Kusin had misled authorities by lying that he was a trained canine handler with the RCMP. At trial, Kusin was awarded $100,000 in damages. The Supreme Court, on appeal, ordered a new trial, and that defense of responsible communication should have been considered. Part of the reasoning, was that once you allow yourself to be praised publicly as a hero, you do open the door for publication on reasons you are not this hero. The defendant's liability at trial will hinge on whether they were diligent in verifying information prior to publication. This is precisely that fourth step of responsibility, whether plaintiff's side of the story was sought and accurately reported. There are two other interesting situations of defamation I'd like to highlight for you. The first, 2011 Supreme Court case, Boo Malab and Diffusion Metro Media CMR Inc., where a shock jock was making comments that the Supreme Court accepted as racist comments about all Arabic and Creole-speaking Montreal tax drivers. The Supreme Court of Canada found that this category of individuals was too, quote, general and vague to give rise to liability under Quebec's civil code. Interestingly, Justice Abella's dissent was that the group was defined with sufficient precision and the statements were specific enough to be harmful to the reputation of each of its members. You can clearly see that if this shock jock was mentioning actual names of the taxi driver, that would have been defamation. So we're willing to go as far as defining specific characteristics of the group. This is, of course, the dissent and not the law in Canada. Doré and Barreau du Quebec, 2012, Supreme Court of Canada. The court reviewed a situation where a lawyer made private comments about a judge after this judge made derogatory remarks in the course of a trial. These defamatory comments by the lawyer, even in private, were held to be defamation. The reasoning behind this is that lawyers should be held to a very high standard in order to preserve civility in the profession. That limitation on protection for freedom of expression in this context really goes to the civility of your speech. As Abella stated in her ruling, lawyers do have a right to express their opinion. They are not verbal eunuchs. The concept of defamation is endlessly fascinating, as our right to freedom of expression, on its face, seems so crucial. How could we have liability in our legal system for just saying something that doesn't approach anywhere near, say, hate speech or threats of violence? But you can clearly see, especially where powerful individuals, powerful media organizations can put out information, if that information is false and there's no checks and balances to correct that, the structure of democracy really could be threatened. It's a difficult area to balance. The United States, for example, makes it harder to find defamation, and this is a very difficult question. But nonetheless, the existence of defamation is an important element of a free society. I find the requirement that the defendant be diligent in ascertaining the truth and give the plaintiff that opportunity to comment and present their side a great check for keeping a balance between freedom of speech, freedom of expression, and journalistic integrity. I do also agree with Canada's assumption of harm perspective in comparison to the US more proof of harm requirement, in that the publication, the putting out of defamatory remarks is always harmful in reality.